How will SCOTUS rule on tariffs? Welcome to Law and Society. Please subscribe. SCOTUS just had a marathon 3-hour oral arguments earlier today, and it is about tariffs and regulate. I will briefly explain to you the oral arguments before pretty much going through the transcript of it, summary of the transcript. So, the government's position, Donald Trump's position, is that the term regulate importation in IEEPA, which is the International Emergency Economic Powers Act, is tantamount to tariffs. That is what John Sauer, the Solicitor General, argued. And no matter what was asked, he came back to that regulate importation is the phrase that means tariffing. Regulate alone may not, but regulate importation, Sauer claims, is giving the president tariffing power. And that is regulatory tariffs and not revenue-generating tariffs. So he's sort of parsing the meaning and sort of being technical, but the court was not having it. The court really was not very happy with Sauer's argument. It's very difficult to gauge Justice Thomas, but with the other justices, even Justice Gorsuch and Chief Justice Roberts, they were both very, very clear on the fact that tariffing is nowhere in the IEEPA statute. The Voss Selections argument, which was presented by Neil Katyal, started out by saying that tariffs are taxes and that Congress has a very specific power to tariff and then regulate foreign commerce. These are two separate powers. And when it comes to tariffing, when it comes to taxing, our legislature and our government has always been very specific in delegating away Congress's tariffing and Congress's taxing power away to the executive. So it has to be very specifically delegated, and Voss Selections and Neil Katyal's position is that tariffs are nowhere mentioned in IEEPA. IEEPA was not designed to be a tariff statute. It is a sanction statute. It allows for various prohibitions and licensing and other things, but it does not speak of tariffs. And in order for Congress to delegate away their tariff power, they have to do it very specifically and very limited way, in a very limited way, because otherwise it is very difficult to get the power back from the president. And that was an issue that the justices talked about, is that if you delegate so freely without saying tariffing power, just by saying regulate importation, then you are making it difficult for Congress to take back its power to tariff in that context from the president when that time elapses. Because no president is going to want to give up their extra powers. And so the impression that I got from all the justices, Justice Alito and Justice Barrett seems to be wanting to throw Neil Katyal off. Whereas on John Sauer's side, it seemed like Chief Justice Roberts, Justice Gorsuch, Justice Kagan and Justice Sotomayor were very, very pointed in their questioning. They were very annoyed by the fact that this issue is being brought up when IEPA doesn't talk about tariffs at all. Okay, that is the summary. IEPA does not give you the power to tariff. That is what the VAS Selections and Learning Resources position is. And the position of the government is that the phrase regulate importation does inherently mean tariff. As it stands, looking at the court, I can see 5 justices ruling to invalidate the tariffs. Chief Justice Roberts, Justice Gorsuch, Justice Sotomayor, Justice Kagan, and Justice Jackson. I don't know how Thomas and Alito would go about it. I don't know how Kavanaugh also seemed like on the cusp. Barrett was also on the cusp, but no one was really accepting the premise that John Sauer came out with, which is that regulate importation means tariff. Okay? With that summary, now if that should be enough for you to get a gist of what this oral arguments was about. I would, if I were to bet, I would bet that the Supreme Court would invalidate the tariffs, but somehow find a way to not burden the government with having to return every dime back to whoever that was tariff. I don't know how that's going to go about, but I don't see the justices really going for the government's position that IEPA gives them the power to regulate importation, and regulate importation inherently means tariff. I don't see that happening. With that said, I'm now going to just look at some of the comments, and the court asks, Justice Kagan asks, what inherent powers does POTUS have to be able to tariff? It doesn't, because regulate and tariff are congressional powers. But John Sauer says the president has broad inherent authority to address foreign policy, which IEPA is addressing here. But Sotomayor says that the congressional power to tax and tariffs are taxes. How is a quota equivalent to revenue raising? Power to impose tariff as it is the same as regulate, says John Sauer. IEPA's purpose, Justice Jackson says, meant to limit presidential authority. Congress concerned how POTUS was using its power. IEPA was designed to constrain the president's authority. And what was the intent if not constraint? Sauer goes back to the same, loops back to regulate importation, and IEPA allows the president to tariff. And it doesn't seem like it was getting through to the justices. So Donald Trump. Then Justice Barrett talks about the usage of the terms, that the verbs that are used along with the adjectives to give power, give presidents specific power. And Sotomayor says there's nothing that talks about raising revenue. It's a regulatory power. Sauer says the regulatory importation phrase gives the government the tariffing power. Congress does not use tariff in IEPA. But according to Sauer, regulate importation means tariffs. Chief Justice Roberts wasn't having it, saying that there is nothing about tariffs in IEPA. The statute doesn't use the word tariff. And again, Sauer goes back to regulate importation inherently means tariff. It's kind of repetitive there. Talks about licensing. Justice Sotomayor talks about licensing, but that does not include revenue raising. The verbs in the statute, Justice Jackson says, are doing something. Congress was authorizing the president to control or free property transactions where foreign interest is involved. And that power does not include the power to raise revenue. It didn't seem like Justice Sotomayor was very happy with Sauer's argument because no president has used tariffing power under IEPA, and whenever Congress allows taxing, it specifically says so. Justice Gorsuch seemed to have a problem with POTUS's inherent authority. He asked whether the president has inherent authority over tariffs in peacetime, and Sauer says no. Congress can always take back these powers, but it's where. So there's that delegation issue, and Justice Gorsuch doesn't seem very happy with the expanding power of the presidency. It's ironic considering he signed on to the Trump v. USA case that gave presidents near total immunity. Maybe you want to reconsider that opinion. Justice Kavanaugh, why have other presidents not used IEPA? Why regulate importation, and why does regulate importation encompass tariffs? Sauer says that regulate importation means tariffs go back to the founding, to the natural way to do that is to tariff. And is a regulatory tariff, but not a revenue-raising tariff. So he's making this distinction between the regulatory tariffs that may impose tariffs, but they don't necessarily have to if you follow the regulations, as opposed to a tariff that is specific to just raising revenue. So if Congress disagrees with SCOTUS's interpretation of IEPA, should they can't just take that power back without a supermajority. So there's that delegation issue there, where the court is saying, you are asking us to give the executive this power that Congress has not explicitly given to the president. It has explicitly given it to Congress, and Congress has to explicitly delegate it to the president. But that also has to be temporary and limited so Congress can get back its tariffing power, as to not, empower the president with taxing power in one avenue of his, that is under his core duties, which is foreign policy. Then we go on to Neil Katyal's argument, and I have to say he's poetic. The way that he talks in front of the Supreme Court, he was born to do it. I would very much like to see a Justice Neil Katyal, but I don't know if that'll ever happen. But I think that he is brilliant in the way that he presents the case. He starts out by saying that tariffs are taxes. Taxing power to Congress is Congress's alone. And here, POTUS has bypassed Congress. IEPA is a sanctioned statute. Congress always explicitly delegates tariff power, and it doesn't do so in IEPA. Justice Thomas talks about embargoes. Tariffs are constitutionally special, Katyal distinguishes, and saying regulate describes embargo-like actions but does not point to raising revenue. You have to delegate tariff power with intelligible principles. To the Chief Justice, Katyal says tariffs have foreign policy implications, but that's Congress's power by way of Article 1, and it must be specifically delegated. Regulate importation has never been used, even once, to impose taxes or revenue raising. This president has torn up the tariff infrastructure. No president has had the power to do this. Alito seems to be wanting to throw Neil Katyal off, but he is not successful. Alito says, does that include imposition of fee? If it raises revenue, it wouldn't be permitted, says Katyal. All tariffs are revenue raising. Katyal says taxation is special and different. Congress has delegated it specifically, and it doesn't in IEPA. And, Alito is trying to throw Katyal off. It's kind of, justices often do that. They play the devil's advocate. It's how the appellate discourse works. Katyal says POTUS can use other authority to tariff. There are other laws that gives them power to tariff. They've used all other tax authorities, but previous presidents have, but they have never used IEPA. And Katyal's position is that IEPA does not allow these tariffs, and tariffs code changes have never happened through IEPA. Are emergency powers generally broad? Neil Katyal says that it's the other way. Emergency powers have serious limits. Tariff power is an exclusive congressional power. It has to be specifically delegated, saying regulate isn't enough. Every delegation of tariff power always has limits. Why use the other laws if POTUS can just use IEPA for all of it? No Article 2 power to tariff. It's a reminder. Definitely not in peacetime. There are tariffing the entire world. Donald Trump is tariffing the entire world during peacetime, and is a whole different animal than what has happened with IEPA with previous presidents, as well as the intention of IEPA to constrain the president, as Justice Jackson pointed out. Justice Kavanaugh says Katyal says statute has to say tariff. In the precedent, Algonquin was about one product. This is about 1 billion products. The precedent was about a trade statute, and this is a sanctioning statute. It's not a tariffing statute. It's a sanctioning statute. Here the government is using a power, Katyal says, that raises $4 trillion. Justice Barrett asks, how will that reimbursement work if Neil Katyal's team wins? And Katyal says the government would have to give companies their refunds. And I'm not sure if I don't know, perhaps that's how equitability would work, but I can't answer that. At the end of the arguments, nothing in legislative history that authorizes presidents to tariff. What does regulate importation do? Justice Jackson. It is about what POTUS have used it for quotas, screening, and for reporting requirements, standards, environmental standards, embargoes, all intended delegations of IEPA. But tariffing is not one of them. So then you have Counsel Gutman, who comes up and speaks for Learning Resources, which is the smaller case brought by toy makers who are going out of business because of these tariffs. And he says POTUS does not have the inherent power to levy tariffs. IEEPA has nothing to do with tariffs. IEEPA gives power to transactions, assets, and embargoes, and it is different than tariffing power. IEEPA is a sanction statute. It is not a tariffing statute. And then there's the rebuttal where Solicitor General Sauer goes back to talking about how regulating importation is tariffing. So then Sauer goes into this sort of hyperbolic talk about bringing industry back to America and everybody buys American, so Americans don't have to pay tariffs. This sort of hypothetical thing that would take decades for the manufacturing hub of everything that Americans consume comes back to the United States. It's just not a practical way of thinking. And he says, and everybody buys American, so Americans don't have to pay tariffs because we don't get anything from other countries. Like, how is that possible in this global economy? So that is how the banter went. And as I said in the summary, I see it as not going very well for the government. I don't see this court saying that IEEPA gives the president the specific power to tariff without stating so anywhere in the law. With that said, I've taken up 20 minutes of your time. Thank you so much. I have put in the references box Congress's website about the history of IEEPA, then the statute IEEPA, then the Supreme Court's oral argument transcript. You can read through it if you'd like. And then there's the oral arguments recording that you can listen to if you'd like. It's 3 hours though, so take some time if you want to go and listen to it. With that said, thank you for listening, and I'll talk to you soon. Remember to like, share, and subscribe, people. It really, really helps me out. I appreciate every single one of you for coming out and listening to me talk about what's happening in this country. And I felt like today's topic is important because tariffs have been raising the prices for American citizens because consumers have to pay the tariffs when prices go up because companies are not going to shoulder the burden. And so far, companies have shouldered some of the burden, but not all of it. So it's important, and it is in the public interest for the court to invalidate the tariffs so prices go down on things almost overnight. And then the government would have to, then the court will have to give the government instructions on what to do with the money that they have already collected, which is a few $1 billion. And Neil Katyal says up to $4 trillion. That's the goal. So take care, everybody.